Welcome to Lecture 5 again. And this is another interesting case where how can you have a duty of loyalty and whistleblowing as well. And here is an employee very loyal and very much injured. And how is the company resolving the issue and how's the court? And this was a famous movie, Silkwood case. And Karen, because of working with this company, she died. And it was not even that she died at work as much as it was over her apartment, to the point where even the apartment burned down, which we don't know who did it or not. But anyhow, the plaintiff in this case is the estate, her parents, her family. And they are alleging that the operation of a nuclear fuel rod fabrication plant is an ultra-hazardous or abnormally dangerous activity. And therefore, the plaintiff therefore alleged that Kerr-McGee Nuclear Corporation is strictly liable to compensate plaintiff for Silkwood injuries. She died, including radioactive contamination of her internal organs, tissues, and genes, and that she experienced mental and emotional trauma, suffering, and anguish. And this is what the trial court jury decided. The reason why I want to share with this case is because the company, Kerr-McGee, they comply with the law. If you had a detection of plutonium at a certain measurement, you couldn't leave the property, or you could not. However, apparently Karen would go in and out of the corporation and bring some of the contamination while she was working to her apartment. So the jury, the court, at the trial court, found negligent. That means even if they were complying with the law, even if they did according to OSHA, the minimum that they could be a sense with the, with the machines, how much radioactive was in her clothes and her body. The fact that she was going in and out in the morning and maybe more than one time, maybe for lunchtime, maybe whatever reason it was, she was carrying some of that toxic or that ultra-hazardous material to her apartment. Her clothes, everything was contaminated. And plaintiff awarded $5,000 property damage because the apartment was burned out, and $5,000 in personal injury, and $10 million for punitive damages. And punitive damages is to punish the company. And of course, you know that Kerr-McGee says, how can you do this to me when we comply with the law? They didn't do anything illegal. They comply with the standard that is expected by OSHA, but that's expected many companies. They try very, very difficult. No company gets up in the morning and says, how can we violate the law today? Company wants to comply with the law. Company wants to keep the corporation safe. Company wants to make society better without harming it. There's no questions about it. Well, the company, Kerr-McGee, appeals. And the appellate court, they affirmed the $5,000 for the property damage. However, they reversed the personal injury damages, which is negligence, because in that state, workers' comp is the exclusive remedy. Workers' comp is the exclusive remedy, and in New Jersey, it's not. In New Jersey, you can file a claim for workers' comp, and you also can take the employer for negligence, if you want to say. And then what the court is saying is, you're going to make a lot more money on the negligence that you're doing on the workers' comp, and then whatever money you won as your final judgment of the court decides in your favor, those money then you're going to compensate back workers' comp. And again, it's a state remedy. Now, and they reversed the punitive damages, federal preemption, because this was a federal case. It was a corporation in a federal case, and they says, hey, punitive damages has nothing to do in a federal court. That's a state situation. So we're not going to do it. We're not going to have negligence either because that state has remedy. So here is a situation where they're in a federal court and they comply with state law. But here is the corporation complying with federal law about safety, how much you can bring out or coming in with it. And it was very interesting, this case, and it's in your textbook, and please read the opinion, because I want you to see how here is the company saying we comply with the law, therefore we were not negligent, therefore we're not supposed to be punished, and then of course if we have only workers' comp, then if anything, then only workers' comp, which you're going to learn later on in lectures, workers' comps is a no-fault insurance to protect the employer. And of course, the United States Supreme Court heard the case too, and they granted on preemptive effect of the federal law or on state punitive damages, no punitive damages. They reversed and remanded the case to the appellate court to determine previously undecided challenge to punitive based on state law. Well, you know, because of the this is a federal situation, and the bottom line is when it comes to money, the state is responsible, not the federal government. So they remanded the case to the appellate court. And of course, what the appellate court does, the appellate court remands it to the trial court for a new trial to find out on the punitive damages. Well, let's see what's really going on here. You know, really, should we have that much money, like millions of dollars? In the meantime, an overfilled cylinder of nuclear material burst after being improperly heated at the plant where 100 workers were killed and other injured, and therefore the case was settled for $3 million, because here's another evidence that even if they comply with the law, people still continues to get hurt. So somebody somewhere, there is a negligence. The critical question, how come KRMG had to pay damages caused by the escape of plutonium from its plant when they were complying with the regulation of OSHA, even though it was compliant with the federal regulation, and one of them was OSHA? And the court says compliance with statutory and regulatory provision does not necessarily lead to inference that negligent conduct is not present. Just because you're complying with the rules and regulation does not mean that you are not negligent. In a way, what the court says, that's the minimum. That's the minimum that the federal government is regulating safety. You know better how hazardous is your material. So for your employee, you were negligent because you know better. Very interesting case, because here is a situation where the company had a legal duty to provide safety even if they were complying with the agency rules and regulation. Do you see an overlap here between ethics and law in this case? Please post your legal and ethical perspective on the board discussion. I really would like to read your view.